Good afternoon, everyone. Allison Schaberg here with Consolidated Planning Group, and we are partnering with the Live Oak community today, as well as the law office of Christina Lesher. So, Christina, welcome. We're glad to be back with you again today.
Thank you, Allison.
We are talking today about the ever popular topic of special needs trust, and there's always a lot of confusion surrounding why and which ones and what do we need and how do we avoid Medicaid paybacks and things like that. So we're going to be talking about all of those things today. So we're glad that you have joined us today. Also, just from a housekeeping perspective, in case you're wondering, we're going from 12 to 1 today. So if you're planning your time, you can plan on that. Today's webinar is being recorded, and later this afternoon, you will get an email with a copy of today's slides, so you don't have to take notes on every single thing you hear or see. And also, you'll get a copy of today's recording as well. So from a webinar perspective, we can't see you or hear you, but we do know that you're there. We want this to be as interactive as possible. So as we're going through the presentation today, if you have questions, if you'll just put those questions in the chat box, I'll be monitoring the chat box for Christina today, and we'll be reading those questions out to her. So just for those that are joining for the first time, we are glad you're here. For those that are coming back and have attended other webinars in the past, we're definitely glad you're back. Consolidated Planning Group, we're a holistic special needs planning firm, and there's differences. There's a lot of confusion a lot of times, Christina, on what it is that we do and what you do. And I think we both get calls for what the other one does, right?
Absolutely.
So I always like to say that that you guys are the paper, the legal documents, and we're the money. Okay,
Yeah.
so we're the money in the right bucket. We're doing protection plans, future care cost estimates, helping people set up ABLE accounts, putting these lifetime care plans, and just really looking at transition planning as well. So I just like to kind of make that, make those lines clear, because a lot of times people are confused on why do they need an attorney? Why do they need an advisor that's focused in special needs? And the truth is your situation is specialized. So one thing that I really like to talk to people about is just like if you were going to the doctor because you had a problem with your heart, you're not going to go to a podiatrist. You're also not going to go to a generalist, a PCP for your heart problem. Typically, you're going to see a specialist. And when it comes to navigating kind of the waters with special needs, I think it's really, really important to seek a specialist as it relates to planning for special needs, because when you don't, and you actually do see a generalist, sometimes you end up with money in the wrong buckets. Sometimes you end up with the child that loses their eligibility for SSI and Medicaid. And folks, I know, Christina, I know you work, with a lot of people, all across the state, and so do I. And one question that we commonly get from families is why? Why do we even want Medicaid? Hey, we have saved up money. We have a trust, or we have enough money to fund our child's future care. Why do we even need Medicaid? And the deal is, in most states, you have to stay Medicaid eligible for all of the waivers. So all of the waivers in the state of Texas, you do have to stay Medicaid eligible. So that's why some of these topics, even if you find yourself affluent, you've got lots of money, lots of things set aside, lots of plans in place, those Medicaid waivers do require Medicaid eligibility. So careful planning is definitely necessary on that. So having said that, I'd like to just turn it over to you, Christina. Tell us a little bit about your firm, where you're at, and let's get going.
So sure. So my name is Christina. Thanks everybody for joining us today. I'm located in Houston, Texas, by the medical center in the Westview area. But like Allison said, we help families all over the state of Texas. I started out with special needs and elder law as a social worker, and then I ended up practicing social work at an elder law attorney and special needs planning attorney in Austin. And He encouraged me to go to law school, and that was in the year 2000. So I've been an attorney since 2003. And I also have a medically fragile nephew who is 11, and that really increased our passion and our desire to help families that were going through a lot of the same things that my sister was. So that's how I wound up here. And we love helping families and love putting the pieces together. And we love building the buckets so that Allison can put the money in it. So that's a great way to explain that.
Well, and I would just like to say that I've had the pleasure of hearing you speak at the UT Special Needs Planning Conference for attorneys and professionals. And Christina is a leader. She is definitely a leader in the state of Texas when it comes to special needs, and has written a lot about this, and really understands a lot of the things that the other attorneys out there don't. So it's the same thing with a special needs planning and advisor, as well as an estate planning attorney that really understands and focuses on special needs. It's just not the same. All attorneys are not created equally in their knowledge and their understanding. They're all smart. They all go to law school, and they're all smart, but they're all also nuanced and various sections of the law. So I had the pleasure of hearing you speak, and it was really great.
Oh, well, thank you. I hope I didn't look as nervous as I probably was, because I mean those UT conferences can be a little intimidating, but I always enjoy updating our paper and speaking and meeting other professionals. So it's good.
No, you do great. Nobody knew you were nervous. So.
So do we want to do the first slide on the roadmap to SNTs?
Is it showing on your screen? It's showing on mine.
Okay. Yeah. Okay. Yeah. Oh, I have it as
perfect.
I have it as next slide.
Oh, interesting. Let's see here. If somebody in the chat box could just say if they see our slides or not. I'm going to just try to reshare that. How about that?
Okay.
Okay. Let's see what somebody else says. Okay. They're saying they can see it. Okay. Perfect. Can you see it on your end now?
Yeah, I sure can. Okay.
Okay. Perfect.
So Allison brought up a really great question, which is why do we need Medicaid? Why do we need supplemental or special needs trust? And just a quick little note, in the state of Texas, we use the term supplemental and special interchangeably. I think there are some other states that the words mean something, but not in Texas. So I have clients that say, listen, we've got all this money, we've got an insurance policy. Why think about Medicaid? Because the cost of care is incredibly expensive, and we don't know what your kiddos' costs are going to be. We definitely want to set up our child with as many public benefits as they could be eligible for. And we do that as part of our succession plan. So when we're thinking about putting together a trust, we want to think about the person that's going to be in charge of the trust, but we also want to give that person in charge of the money, known as the trustee, as many options for paying for your child's care as possible. So we plan for the wealth transfer at a parent's illness, even, or death. And we use the supplemental needs trust, number one, to create a bucket that money and assets can go into that's not going to disqualify your child or loved one for Social Security and Medicaid benefits. As the slide indicates, many Medicaid and Social Security requires that the assets in your child's name have to be below $2,000. And as we'll talk about in just a moment, the Medicaid has over 109 different programs, and they all have different varying income and asset requirements, but typically we look at that $2,000 asset requirement. That's not a lot of money to have in an individual's name. I'm going to have Allison help me out with this ABLE account that we'll talk about in a few slides. It will allow a person who's on Social Security and Medicaid to have an excess of $2,000. But we look at these supplemental needs trusts to pay for things that Medicaid may not pay for, such as certain type of housing, education, life-enhancing experiences. What I look at Medicaid is a great way to pay for medical care and housing, and then maybe we look at the money coming into the trust to help pay for the things that the parents will provide or the caregivers will provide. I tell the clients, think about everything you do for your child and how much money it is going to cost to replace your services. And Allison, so do you look at those numbers too when you're figuring out how much to fund these buckets that the lawyers create?
Yes, we have basically for all states the average cost of care, and when we're doing future cost estimates, we keep in mind because here's a lot of families come to us and they say, we're hopeful and optimistic, but little Johnny isn't there yet.
Right.
And so what we say is let's plan for the worst and hope for the best. And when the best happens, then you have a more lucrative retirement.
Right.
Maybe you can travel more in retirement.
Yes.
Maybe you can step out of work earlier than what you had planned or things like that.
Yeah.
So that's typically what we do. But then whenever we're doing the future care cost estimates, we kind of, whether it's, bronze, silver, and gold or small, medium, and large, what if you have care in the home and you have a caregiver coming in? What if they have a day program that they go to, maybe partial residential? What about full residential? And we kind of look at the different the different types of care that the person can get, and then the areas of in which you feel that they may get the care. Is it the Houston area? Is it San Antonio?
Right.
Is it Austin?
Right.
Is it San Francisco? Wherever it might be, right? And so we're able to cost that out, and then we have inflation calculators and everything that cost it out for the future. So if it's 40 years from now, because you're planning on your loved one being with you until whenever, right? It actually can cost it out that way as well. But one thing I want to say before we move on from this slide, because this is, and actually we had a case, and we actually referred them to you, and this was an interesting and eye-opening case. And actually, we're going to have a webinar with this guy. But we had somebody that came to us who was from out of state, whose cousin was in this state. And they, and both the parents had died, and basically nothing was set up. And there was people on the ground in Texas that were trying to help the individual, but they were also trying, inadvertently going to mess up his waiver that he waited for 17 years to get or whatever. And so anyway, but that plan for incapacity and illness is so important. And the thing is the years clip by quick, and our lives are busy and they're full and they're complicated. And before you know it, you're not as young as you used to be. So having these plans in place is going to make it a lot easier. So there isn't somebody from out of state, a family member, trying to navigate care for a person that maybe can't navigate care for themselves at all. So I think it's just really, really important. And I know that's why you guys are all here, but we see these things all the time where the best laid intentions it was the thing that was on the shelf that we're going to do. Yes. And we're going to get to it, and then we never do, and then something happens. So I just can't convey that enough. You don't have to have $1 million to get started. It's not like that. It's just kind of working through. And I know Christina's office, and so do we really partner with the family. What is important to you? What do you already have in place? What does the future look like? We have some families that definitively want their child to move on to a transition program or move to a residential or have some autonomy. There's all kinds of things. And then we have other families that say, well, no, we expect our child will live with us until we can no longer care for them. And the thing is none of those things are wrong. It's a matter of preference. Right. And it's a matter of designing that plan around those preferences for the family. And when you make those intentional decisions now, those unintentional things won't happen later, because when there's a lack of a plan in place, some decisions are made for your loved one, and they may be decisions that you don't want.
Exactly. So when we're thinking about incapacity and illness, that's usually not the first thing that families want to talk about. Allison, at your office, I don't know how it is, but most of my clients come in focused on death planning. And I tell them that really the harder part is incapacity and illness. And we have guardianship and supported decision making. Both of these topics could apply to not only the parents and caregivers, but also for the people they're caring for. So I typically try to avoid guardianship if I can. That is my personal preference for clients, because guardianship is necessary for some cases, but it does involve lawyers, it does involve court costs, it does involve maintaining things. And I honestly would like clients to spend money and time doing other things. So if you are, even if you're married, you and your spouse or your partner, or you, if you're not married or you don't have a partner, you need a financial power of attorney. One of the things I tell the families is we need to make sure that financial power of attorney has language in it that allows the person appointed to spend money on your child. So we don't want to have a financial power of attorney that's drafted so narrowly that the agent legally cannot make distributions for your child. We also want to make sure that the language has distributions, or the ability for making gifts for a disabled loved one, whether it's a child or any other individual that's a family member, to qualify you for Medicaid if it's necessary. And just keep in mind, just because you've been married for many, many years, that doesn't mean that you have automatically the ability to manage your spouse's or your loved one's finances. One little tip that I have there is, once you get that financial power of attorney done, send it to the financial institutions for pre-approval, especially on those retirement accounts. Just because someone is the beneficiary of an account doesn't give them management rights or capabilities during your lifetime. So I've been married over 22 years. I've given our retirement accounts a copy of our financial power of attorney. So if I or my husband becomes incapacitated, we can make investment changes, ask questions, and so forth. One of the questions I get a lot at my office is, do I need to appoint somebody to make the same decisions for financial and medical? This is going to be advice for any appointment. You have to appoint the person that can do the best job. And remember, this is not a position of honor. So you need to have someone that is willing to do it and has agreed to do it. Medical power of attorney, that's an appointment for someone to make medical decisions for you when you can't. A HIPAA release, that's the medical privacy information. My one note for families on this is, anybody that touches your money or is in charge of your money at some point also needs to be on your HIPAA release for billing purposes. And directive to physicians, that's a person that can make decisions in case of end of life. We have a lot of concerns around the guardianship, primarily families being told that once your child turns 18, he or she has to get guardianship. I say that's always a case-by-case basis, like what Allison was talking about, the housing. No one decision is right for everybody, and no one decision is wrong for everybody or for you. There's no wrong decision. It depends on your particular family situation. Sometimes families.
Christina, can I ask
Sure.
something? I think I understand, and I'm not an attorney and I don't play one on TV, but I understand that there's some law in the state of Texas that basically, in a nutshell, is the least restrictive, most appropriate. Right. Is when you're looking or thinking about guardianship, and we know from other webinars that you can start the guardianship process 6 months before they turn 18. Mm-hmm. And while there are some times that guardianship is definitively necessary, maybe the intellectual disability, maybe they're completely incapacitated. There's a lot of things. Mm-hmm. But the truth is the right attorney is going to apply that kind of least restrictive, most appropriate, or whatever that law is. Yes, and they're going to walk you through their your options. You don't have to go to an attorney and know what you need. Right. They're going to talk to you about each one of these things and really have a better understanding of your child, and then be able to kind of talk you through and kind of direct what might be the best path. So you don't have to know when you start that conversation to know what's best. No.
And that's such a great point. All you have to know is it's something you're worried about. And that's all you have. And that's true for every single thing we're talking about. You have a worry, you write it down, you go see an attorney, and that's our job.
For sure. And
yeah.
one last thing I wanted to mention here, because I'm a huge proponent of these medical power of attorneys as well, and the power of attorney. A power of attorney can be activated now or on after somebody has become incapacitated. But I'm a huge fan of having intentional conversations with your aging parents or aging family members about this. And I am a huge proponent of having this when you send a kid to college. Okay. Because anything can happen. We've heard, over the years where there was a fire at a dorm at Texas State, at an apartment complex at Texas State, and kids were transported. And again, without these things, nobody's talking to anybody. If a kid has a mental health crisis and they're transported to a mental health facility, this kind of stuff in place, they're over 18, they're not talking to you. So it's real important. And I think a lot of times we're so busy talking and thinking about our kids with special needs that we forget some other important people in our life that we need to have these conversations with before it's too late.
Yeah. So the takeaway is everybody over 18 needs to have these documents, or at least have a conversation about having these documents. And I agree. I'm sending, when I send my kids off to hopefully Texas State, because that's my alma mater, we'll get powers of attorney done for them. Sam Houston's good too. Don't worry. I know Allison's had a kiddo that graduated from Sam. That's my hometown. But yeah, any kiddo going to college needs them. The supported decision-making, I think it's kind of a bridge to me, it's a bridge document where it allows a third party to communicate, but not make decisions for another person. So maybe someone's not quite ready to sign a power of attorney because they're not comfortable giving that ability to somebody else to make decisions. But keep in mind, the medical power of attorney is only effective when you cannot make a medical decision. And on the financial power of attorney, you can decide if you want to make it effective now or at your incapacity. So the supported decision making may be kind of a bridge document. But let's go to the next slide and talk a little bit more about guardianship. So, like we talked about, one guardianship decision for one family is not the right for the guardianship for all family. And I really think this is where it's going to be a mix of the factors of the family. If their parents are divorced, if the child has risky behavior, if the child is at risk for being taken of advantage financially by somebody else. But what I want to tell you about guardianship is, number one, if it passes your child's 18th birthday, you can still get it done at any time. So don't feel pressured by the school district even. Allison, one day I need to send you this document. It's called an educational power of attorney. I don't know if I've sent this to you or not, but it's a power of attorney that I've created. So that means it has no statutory backup. But what it does is it says, dear school district, I'm over the age of 18. I give my mom permission to go to my ARD meetings, to help me review my IEP, and to help make decisions with me about that. So sometimes the school districts, I feel, pressure the families to get that done. So that's where you come in and talk to an attorney. Because what the school districts don't always recognize is that guardianship is expensive. There are ways to go through the U of H and I believe South Texas College of Law. Both those law schools have legal clinics that will help families, but there's sometimes a wait. And it is a lawsuit, meaning once you apply to be a guardian, your child will be served. They will be served by a constable. They will be appointed an attorney ad litem, and it does require court supervision and court approval. So what that means is if you move your child to a different county or you want to move your child to a different state, you have to get court permission. So I think some of these things are left out in the conversation about guardianship, and it is very difficult to remove. Years ago, I had a family who had placed their daughter under guardianship so that she got out of a lease at an apartment. Well, once they thought she got out of the lease at the apartment, they could just go to the court and say, we don't need this anymore. We want her to not be under a guardianship. Court, we don't want to have to report to you. And the court said, sorry, you have to show us that whatever the medical or the psychological condition that brought you to the court has changed. And so and then you have to, of course, comply with the annual reports. In the second bullet point there, we just talked about preparing for the parent and caregiver incapacity. The takeaway from this is you want to do planning, not just for yourself, but so the other family members, the people in your life, are not left having to pick up the pieces and make decisions in a very difficult and stressful. So the planning ultimately may benefit your child, but you also want to make sure that you give the people who are in charge of that money everything they need to do the job. Okay, so Allison is giving me the third-party supplemental needs trust. So I want to take just a moment to talk about what a trust is, because I come from a long line of school teachers, and we don't talk about trust when I was growing up. We talked about, literature. My dad was an English teacher and so forth, but we didn't talk about trust. So I want you to think about a trust like a bucket, like a bowl, and we can place money in these trusts so that any money in the trust is not counted as financially belonging to your child when looking at Social Security and Medicaid benefits. These types of third-party trusts mean they came from the third party, meaning not your kiddo's money. And anybody can set these up. They do have to be disclosed to Medicaid and Social Security if it's funded, meaning there's money in it. And you can put them in a will or a revocable trust. Now, the decision of having a will or revocable trust is going to be just as personal as a guardianship. It's going to depend on who you are and where you are in life. If you are an older person or a retired person, I probably will suggest a revocable trust, because you're going to get a lot more benefit to that when you die, meaning you don't have to go through probate, and it's a little bit easier transition. I have a will because I have a very busy life, and I don't always have time to add things to a trust if I had one. Not that I have that much, but I like to keep things very simple. So a will or a revocable trust just kind of depends on the family. If you have out-of-state property, I will definitely recommend a revocable trust so you don't have to do probate in Texas and whatever other state. But the last bullet point, you're going to see this language repeated throughout our slides, because Allison and I obsess about beneficiary designations, because we know that if you have a beautifully drafted third-party supplemental needs trust where the money can go to any person at your child's death, if you make a mistake and name your kiddo in their individual capacity, meaning not the trustee, you will do two things. Number one, you will probably disqualify him or her for whatever public benefit they're on. And number two, you will probably cause the need for what we call a first party trust, meaning the money now has to go to a trust where there's a payback provision to the state of Texas. So what I like to do is I have an Excel spreadsheet, and I like to draft and have a list of every account, every asset that the client has. I want to know where that asset goes at the death. And then I want to see a letter from the financial institution confirming that they also agree that the asset's going to go into that supplemental needs trust. So in other words, the takeaway is the beneficiary designation will control regardless of what your will or your trust says. Now, Allison, I know.
So it's not enough. So it's not enough. The bottom line is once you get these documents done with an attorney, that's when you go back to your advisor, your financial advisor, if you have one, or any of those insurance companies, old 401ks, 403bs, pension plans, the list goes on and on. Anything that you can have a beneficiary, you need to request new beneficiary forms so you can update the beneficiary to have the wording. Maybe it's a contingent beneficiary, maybe it's a primary beneficiary. Mm-hmm. Everybody does it a little bit differently, mm-hmm. but you definitely need to update these forms, and a lot of people miss that. But I want to take our attention back to the middle just for a second, because I hear sometimes there's confusion on this. Okay. You said it can be in a will, or it could be a revocable trust, and when you say that, is what you're meaning here is, on the revocable trust side, you can have a standalone special needs trust, or in the confines of your will, you could have a testamentary special needs trust, which basically forms upon your death, right? Can you talk a little bit more about that?
So first of all, the will is not effective until you die. So we draft lots of wills, we sign them, but they're not utilized or not not legal until you die, because that's the event that requires the will to become effectuated. Within the document of the will, you can have a supplemental needs trust. And in the will, you could say, I give a third, I have 3 kids, I give a third to each child. And then my kiddo that is on Medicaid or maybe on Medicaid, he or she gets theirs in a supplemental needs trust. And that trust is actually located in the body of the will. Then your other option is that you can have a supplemental needs trust that is outside of the will, or a revocable trust, meaning it stands alone, meaning you have created it during your lifetime and maybe put just a little bit of money in it, and you've directed your life insurance to go to that supplemental needs trust. I know this is a little bit muddy and complicated, but here's my recommendation for the families. Because your child may not be able to wait the 60 to 90 days that probate is going to take, even if you have a will, I also encourage you to have a standalone supplemental needs trust, so that there's immediate funding of that trust at your death while your family or your loved ones are going through the administrative probate process. So you actually can do both. You can have a will, and it has what we call a pro-over provision in it, which says, you know what, at my death, I'm going to leave my estate to my 3 kids. However, I'm going to create this separate and apart supplemental needs trust for my kiddo who needs Medicaid, and I'm going to make sure that my life insurance policy gets paid directly to that supplemental needs trust, which doesn't require the probate court being involved, because you've updated your beneficiary designation. I hope I made that clear, but Allison,
yes, but I'm in agreement with the standalone, because I've settled estates before, and the trust definitely makes it go a lot smoother if it's already set up. It's a lot faster. Money in hands are quicker. So I am in agreement with that, but it does cost money to set up a special needs trust. And if money's tight right now, or, you know, like there's no funding for a trust until you die because your life insurance proceeds, if you simply can't afford to set up a standalone, then having a testamentary trust inside of your will is fine. And don't feel like it's not don't feel like it's not okay. We got a couple of questions I'm going to run by you. So first, what if you have more than one child? And I'm assuming she needs more than one special needs child, but most people have more than one child. So let's say we've got one special needs child and other children that are not special needs, but let's talk about 2. What if we have 2 special needs children? Do we need 2 third-party special needs trusts in that example, or can you get by with 1, or what do you recommend on that?
So I'm going to tell you what the law says, and then I'll tell you what my recommendation is. If it's a third-party supplemental needs trust, meaning the assets have never touched that child, you can have 2 beneficiaries of the same trust. I would never suggest this, because then you put your trustee, who has what we call a financial or fiduciary responsibility, in a very toggle situation on who gets more of this trust assets. So again, it kind of goes back to every family's different. The family may say, well, I'm not sure, you know, I've got 2 special needs kiddos. I don't know who's going to need what money. I would say it's better to maybe change the funding as you go through life with a beneficiary designation, rather than them have be co-beneficiaries of one trust. I think whoever you pick as a trustee is going to be in a very awkward position.
For sure. Okay, so we have another one. We have a special needs trust set up by our attorney, and we're ready to put some money in. Can we just take our legal documents to Bank of America and have them set up the special needs trust for us? And I actually have a funny experience on that.
Let's hear this, because I want to hear. Let's hear this.
What my takeaway is, in general, your general consumer bankers, when you go into the bank, whether it's Wells Fargo, Chase, or Bank of America, most of them do not have any idea how to set up a trust account, but they do have an 800 number that they can call, and it's a very slow process, and they'll get somebody on the phone that will help you. You do need your tax ID for the trust. There does need to be a tax ID. And what is it? The certification of trust powers. That little document is necessary.
And the certificate of trust is just like, remember Cliff Notes from a long time ago, Cliff Notes, which is just like the little summary of the trust power, so you don't have to go in there with the whole trust document. My suggestion is, I hope no one works for Bank of America, is not to use Bank of America, but to use a Texas-based bank like Bank of Texas, Frost Bank,
Cadence.
Cadence. I would tell you that Bank of America is not my most user-friendly, because like you said, the young person behind the desk is gonna be like, I don't know what you're talking about. The other question you're gonna get is there a cost to setting this up? If a bank is not in charge of the money as a trustee, it should just be the same cost that it would be to open any other account.
Yeah, I can say I have successfully opened with Bank of America and Wells Fargo, but it was painful.
I was like, did you find a good contact? But you know, the other thing too is you could walk into the front desk if you really feel committed to Bank of America. You can walk into the front desk and say, I need a personal banker. Can you have someone call me? And then that way you have like one person to go through and not have to call away a home number.
And like I said, both of those places, they have phone numbers. The general, it's just not general training that these consumer bankers get. They don't do it very often. And like one time, once they were like, what is it again? Like they were really confused, but they did get it set up. I mean, I already knew going in, you should just know going in, it's going to be like that. You need the tax ID, bring your documents. They're going to tell you emphatically that they need an entire copy of your trust, which I guess fundamentally I have a problem with it, but ultimately I went ahead and gave it to them because I was like, okay, we're getting nowhere here, but they really don't need the full copy of the trust. So anyway, but it definitely can be set up, and it, you know, and it doesn't take forever, but they're going to get the 800 number on the phone for sure.
So this is such a good next topic, which is now that we have our trust, and we're thinking about setting things up, who is going to be in charge of the money? And a lot of times clients will say, well, the sibling's going to be the trustee, which is not always necessarily the best idea. It's not necessarily the worst idea, but I'm a big proponent of siblings always being siblings. I like, if you're going to appoint a sibling as a trustee or a person in charge of the money, do something that's called a trust protector. And what that trust protector does is it says, listen, at some point, I may not want to be in charge of the investments and paying the bills. Maybe I want to hire a private fiduciary like a bank, and I just want to be able to get financial statements from them, ask questions, and not have as much responsibility. But if they don't do a good job, I can move them without having to go to court. So I think if you're going to have a sibling, that's fine. We just need to be able to give them a parachute out of that big full trustee role. So this is actually a topic I have at my house. So I have a nephew who will most likely need some type of Medicaid benefit throughout his life. And I have two sons. My nephew's an only child. So we have conversations in our house now, like if James needs help in the future, who's going to do it? And we start talking about how much responsibility they are going to want. So I have a 15-year-old, and he said that he wouldn't want to have to pay the bills, but he felt like he could go and talk to somebody if he felt that the trustee was not spending enough money on his cousin. So you can also think about other family members as trustees. And I think you need to have a review once a year to make sure the people that you have named in the document are still able and willing to have that role. Maybe they have a life change. Maybe they have had an illness or divorce and it's not a good fit. The other thing you want to think about is the distribution language. This is kind of my pet peeve. Well, nothing will get my blood boiling more than seeing a trust that is too restrictive. And again, primarily we're thinking about third-party trusts here. I don't want a trust to say distributions cannot be made for food or shelter, because that is absolutely too restrictive. I want it to be able to have it be where the trustee can make distributions, even if it means maybe they get less Social Security, if that's what they think is in that person's best interest. The letter of intent is a written document for the parents to communicate to the trustees how they want that bucket of money spent. So a lot of times in supplemental needs trust, the trust language is very lawyerly, it's very dry, doesn't really express the emotion and the hopes. So I like these letter of intents to talk things about, like, dear trustee, if my if there's a sibling that's willing to host or have as a residence the kiddo that has a special need in their home, they can make home modifications, they can get paid from the trust. So those types of special instructions that you want to give to the trustee that we don't necessarily put in the trust document. So because as your family grows and changes, you want to have that flexibility without having to redo the whole trust document. Okay.
Let's talk about that. So we actually do have a webinar.
I was going to say, y'all have a webinar. Really good.
We do have a webinar for a letter of intent, and we actually have a template. It's actually 20 pages long. It's form fillable, and it really this is just a document to put in the hands of somebody else. If you're incapacitated, you're not here anymore. I kind of call it a family love letter too. Kind of like, it's like that. This is you eat, sleep, and breathe your child. You have forgotten more than anybody will ever know. And this is just putting it on paper. They're never going to be able to step into your shoes completely. But what we want them to do is, when they do have to step in, that it can go as smooth as possible. Yeah. And you can there's a lot of space to speak your heart. There's a lot of facts, like, where did your child go to school, and what are the diagnoses, and what are the meds, and who are the doctors, and what county was he born in? There's so many. What are the religious preferences? It goes on and on and on. But there's a lot of space in this letter to speak from your heart and what your wishes are, not just in black and white, the facts, but to really speak from your heart. So we do think that this is definitely an important component to planning, for sure.
And if you don't like a form, because I have some clients that just hate filling out forms, I'll tell them, just write a letter. It doesn't have to be a form filling out. Okay, let's go to our next slide.
And then also, someone says, instead of a beneficiary at a bank or a financial institution, can you make the beneficiary default to the will? Usually, I'm familiar with a transfer on death or a payable on death, TOD or POD. What do you think about that, Christina?
I think it depends on the asset. I know there's some brokerage accounts that have to be set up as tenants in common, which means it has to be paid according to the will. Like anything else, you can do it, but the bigger question is, should you do it? I would say if you do make it default to the will, the actual language would be to your estate. And you will want to make sure that at some person is on your bank account, and there's enough money in that bank account to get your child through, I would say, 4 to 6 months of probate administration. So you can do that, but then on the other side is you may want to have a checking account and add your executor or your trusted family member to that account to pay for living expenses while your will is being administered. Because here's the thing.
It's easy and free to do a change of beneficiary. Yes. So I have to say, my preference is, I really hate it when it just says the estate, or it's really a lot better if you use the beneficiary forms, and it's a lot less convoluted.
But the flip side of that coin is sometimes you want to have some assets go to the estate so that there is money available to pay for estate expenses, and it doesn't make it more muddy. So I know I'm not giving a super clear answer because it's so fact specific.
To the person.
Yeah, it's definitely personal to your situation. So what assets to fund into the trust? Some assets work better than others depending on the liquidity. Like if you have a house that's co-owned with 3 or 4 other family members, a supplemental needs trust may not be the best recipient of that. You may want to leave a different type of asset. So in other words, you don't have to leave every asset equally to each family member. You can do a percentage of the overall estate and kind of pick and choose the assets that work best.
Christina, I want to mention something that you just talked about, because I've actually seen a lot of this, and it's interesting. In the last month,
Okay.
I've seen a lot of like investment accounts or brokerage accounts set up as joint tenants in common when they should have been set up as joint with rights of survivorship.
Right.
So it's like they are set up in error. Like a joint tenant in common might be like, if like Christina, if you have an account with your brother, then your part is going to go to your family and his part's going to go to his family. But I've been seeing spousal accounts not in, and now sometimes it is right? Because you've got his, hers, and our kids and kids from previous marriages and stuff like that. But you may want to look at your brokerage accounts and your joint accounts. Are they set up of joint with rights of survivorship, or joint with tenants, as tenants in common? Because that really does make a difference. So I'm glad you brought that up.
Yeah, but I do know that there's some types of investments when they're set up in brokerage accounts that buy some type of, I don't know what statute, or if it's some type of internal policy at the bank, they have to do it as tenants in common. They will not give you that option. So just be aware of that too when you're setting up an investment. So many questions to ask. We're kind of in the weeds here. So if we're overwhelming you, don't worry about it. That's okay. The big picture you need to take away is some assets may work better in your trust than others, and the lawyer and a CPA and a financial advisor will help you figure that out. That we talked about the professionals you need. Go back just one real quick. I cannot. Thanks, Allison. I cannot overemphasize the need for a good CPA. So if you're doing your own taxes and you're like over the age of 65, now's the time to at least partner with a CPA, because even though, and I'm talking to those engineers out there, because they like to do their tax returns themselves. But if your spouse has never filed a tax return and has no idea how to do that, then you may want to have a professional that he or she can work with at your incapacity or your death. Because we see a lot of people who the spouse has already done the tax return and the person becomes incapacitated or dies, and the spouse is really in a tough position. A micro board is something that, I could talk about that for hours, but basically it's a group of professionals that come together to give the trustee and the caregivers guidance and advice. It's not necessarily somebody that has to have a background in special needs, but maybe you've got like that one neighbor that is so awesome and loves your family and you feel very close to, and maybe they work at a hospital and they've got a whole Rolodex of resources. I know that's an old term for y'all young people in the audience. Rolodex was actually paper that we used to put phone numbers on, but we're looking for people you love and trust, their recommendations and their ideas to support the people who are going to be doing this heavy duty lifting.
Can you talk just for a minute, and I know that's probably kind of a whole can of worms, but about a corporate trustee? Like some families, we have families that come to us every month that say, literally, there's no one that can manage the trust. I got nobody. So talk about a corporate trustee, and then talk about what is a trust protector.
Okay, so a corporate trustee is a bank. It's a financial institution, and they will be in charge of the money. And this is a common way to solve that problem of we don't have anybody. The downside to using the corporate trustee, and Allison, this is where you guys come in, is that many of these corporate trustees have minimums, meaning you don't even get to talk about hiring them if you have over $1 million. Well, maybe that's why we look at a life insurance policy, so we always have at least the option of a corporate trustee. And what the trust protector can do is the trust protector can select that corporate trustee at the time that the trust is funded. Unless you are, say, 80 and above, I am not necessarily marrying anybody to a corporate trustee, because if I've got somebody in their lives that they trust that can select a corporate trustee at the time of need, that's what I do. So that's what the trust protector does, is they say, okay, I need to get a corporate fiduciary. I've got $2 million in life insurance. And then the trust protector steps in and kind of oversees and makes sure that that corporate trustee is doing a good job. And if they're not, then they get to pick somebody else to do a good job.
And then is there a such thing as having a trust protector? So like, say, for instance, I have a special needs trust, and say, for instance, I've named my sister as the trustee. Is there a such thing as a trust protector to, protect the assets in the event of, impropriety of a family member that is a trustee? Or how does that work?
Well, I usually won't do that combo because that is a straight ticket to litigation. I may have done it once or twice, but it's very, very unusual in my practice, because then I have like your sister versus whoever the other person is. We usually
saying that they're doing something wrong when they're really not, and they just want to manage the trust. Got it.
We've talked a lot about a bunch of wills. We've had a bunch of conversations so far about wills. I know we're kind of headed towards one, so I just want to be sure. The takeaway on the will is it requires probate. Even if the will names the spouse, you still have to go through the administrative process. It is less expensive. And be sure you update and review your beneficiary designations. And I know Allison and I sound like a broken record, but it's so important. Okay, let's do the next slide. We talked about revocable trusts a little bit. It can include a supplemental needs trust. The one thing here's kind of the added bonus is that we use revocable living trust to avoid Medicaid estate recovery. So if you own a home and you apply for Medicaid, unless you have a spouse or some other exemption, Medicaid may try to get the house. That would not include a home that would be located in a supplemental needs trust. So for example, if you have an individual who is on Medicaid, they have a house in their own name, we would use something that's called a ladybird deed, and we would use that revocable living trust to avoid Medicaid from getting the house at their death. That's typically the way that, that's another way that we use these revocable trusts. Okay, let's do the next slide. So here's the big question. Why not just I'm going to use myself as an example. Why wouldn't my sister just give me all her money for my nephew? Because I'm a responsible person. I'm a lawyer. I've got kids. I'm married. I live a pretty boring lifestyle. You know why we've set up a trust for my nephew is because if I am sued, or if I'm in a car accident, or if I get divorced, I don't want the money set up for my nephew James to get wrapped up in that. There's no succession planning. There's no person to name it. If I die and the money's in my name, it goes to my estate. And we don't want to just give assets away if somebody owns them, because we know that there is a look back period or a penalty period for Medicaid, meaning if you own assets and you give them away, number one, you have to let Social Security and Medicaid know. And if you don't tell them, you could get in a lot of trouble and it's fraud. So we don't want to do that. So that's why supplemental needs trust, special needs trusts are so important. Okay, next slide.
Well, can we just talk about the 3-year look back period for SSI and Medicaid? So in an example, let's say we have a 17-year-old and he's got $10,000 in his name. And we know that if he has more than $2,000 in his name, that he's not going to qualify for SSI and Medicaid when he turns 18. Even though there's a 3-year look back period, there are 2 places that they can have money that's not going to be accounted against them. Right. And that's the special needs trust and the ABLE account, correct?
That's true. A first party supplemental needs trust or an ABLE account. Absolutely.
So the money can move to that. My point is even though there's a 3-year look back period, the money can legally move to the ABLE account or to the special needs trust to maintain their eligibility for qualifications for SSI and Medicaid.
Right.
And the reason I bring this up is because all the time people talk to us and be like, well, can I just move the money? Well, you can't just move the money to your account, or can I just, now, can you spend the money down? Yes, but you need to show proof. You need to show proof on what you spent it on, because they're looking back at this. Maybe you bought a car with it. It's totally legit. That's fine.
And even if you spend down, you still have to show it to Medicaid. So anytime you apply for Medicaid or Social Security, you have to be prepared to explain to them any asset that your child, or you, if you're applying, gave away, transferred, or spent down within the last 5 years. So we're not
You can't
talking,
just close the account is the
No,
point. Yeah,
no.
or just move it
no.
to your account or to a different kid. So avoid that. And if that has crossed your mind before, it has crossed everyone's mind before.
Of
So you're not
course, 'cause
alone.
it's so much more simple.
Yes, but you totally can move it to an ABLE
Yes.
account or the special needs trust,
Yes.
and you don't have to wait for 3 years to apply for SSI and
Yeah.
Medicaid. I just want to make
You
that
just have,
point.
and that's a good point. It's not a 3-year penalty period. It's a 3-year look back period. Meaning it's a disclosure period.
Right.
Yep.
For sure. Okay. And then also, another thing, because we've definitely heard on, let's give our assets to the family member to hold.
Oh, yeah.
And I mean, and then again, it's not just divorce, but what if somebody dies and there's so many issues. And then we've also seen where like life happens to the other family member. So it's not that the family member's bad. So maybe the sibling is holding the money and the sibling's going to provide care for the other kid or what have you, but then there's some kind of crisis in the sibling's life or something. There's just so many things that are not a good way forward with that.
Right.
So definitely think about that and consider changing it if you have it set up that way.
So I want to talk a little bit about second marriage or third marriage issues. It gets very, very complicated when we're talking about second marriage, especially if we have his and her and our kids, depending on where that child that has a disability lands, where they come from. My preference is that if you have a second or third marriage, that at your death, that you make sure that your child has something given to them into their supplemental needs trust or special needs trust. Meaning don't give it all to the spouse who could remarry and then not necessarily fund that supplemental needs trust at his or her death. So that's my, and that's actually advice that I would give, even if the child doesn't have a disability. If you're in a second marriage situation and you do have the ability to give something to your children, I think you should, so that they don't have to wait for your current spouse to pass away. And we do that, number one, for funding purposes, for special needs purposes, but also for family harmony purposes as well.
And also, like, there's a thing that you can do to where it can't be, it certainly can't be changed either.
Mm-hmm.
So that way, if one parent is saying, hey, I want to make sure that my kids are taken care
Mm-hmm.
of if I die first, that it can't be changed later, because there is a such thing as trust being changed and,
Mm-hmm.
people definitely being cut out. So I do think that that's an important thing. I know that we're almost out of time, but someone says, I don't know how much money to add to a special needs trust for my son. That's where we come in. We do
Yes.
the future care cost
Yes.
estimate. And
Yes.
that's where we were talking about where we can do partial care, full care.
Yeah.
We can change the ages. There's all kinds of stuff. So we can give you those numbers, those future care cost estimates. But the question is if I add a lot of money to the trust, once he dies, does the money go to the state, or can we set up siblings as beneficiaries so the siblings can get the money if my special needs child
That's
dies?
such a great question. And the answer is, if you do it correctly, absolutely. Absolutely. We use that third party trust, meaning you make sure that your child with a disability never receives anything in their outright name, that their trust receives it in their place.
Well, and then also just, and we'll, have other, deeper conversations, but the first party special needs trust, that's the kids' money. Maybe they got
Mm-hmm.
a settlement, right?
Mm-hmm.
That does have a Medicaid payback, but
Yes.
to her point, there is no Medicaid payback on that third party special
Correct.
needs trust, right?
Correct.
Okay.
Correct.
Perfect.
And that's why you need to go to a lawyer that knows what they're doing. Otherwise, we see third party trusts that have payback provisions to the state when they're not required. And by the way, if that happens, you still have to pay back the state, even if it was what we call a Scrivener's or a drafting error. I've worked on those
I've seen that too.
I've worked on those cases and they're really sad. Yeah.
It's just what happens when attorneys dabble in special needs.
I know,
they have good intentions.
No,
they have good intentions, and they get one little piece of it has to be in there in the eyes of the Social Security Administration, but they miss the part of the first party special needs trust for sure.
Let's go to the next one, because I think we talked about this. Yeah, this is the first party trust that Allison was talking about. So I call these the oops trust. Like, something has gone down, something has happened, and it may be as big as there's some kind of illness or injury, or you may have just been in a little fender bender and the insurance company wants to write out a check to your kiddo for $20,000 and your child is on SSI and Medicaid, and you're like, oh my gosh, snap, what are we going to do? So we have some different options. You, like Allison said, you can do an ABLE account, which is achieving a better life experience. And you can fund up to $16,000 from the ABLE account. This presentation is too limited for us to go into all the nooks and crannies of the ABLE, but I know Allison's got a great webinar on it. Your takeaway on the first party trust, number one, is that it has to be established by a parent, grandparent, guardian, or court order, or by the beneficiary. It has to, the money has to go in before the beneficiary's 65th birthday. And there is a repayment back to the state of Texas. And we can use this also with child support to avoid a loss of SSI eligibility. But yeah, in my office, I call these oops trusts, just so to help parents differentiate between the first party and the third party. First party meaning it's the money of the kids from whatever, maybe it's from work, maybe it's from a fender bender, maybe it's from some type of illness or injury.
When it comes to this, I read something that is kind of out there, and of course, laws changing about, Medicaid paybacks. It's kind of, I call it the slow boat to China, and actually happening. But have you heard anything about that, on kind of where that stands? Because I know that it's kind of been being talked about eliminating the Medicaid payback.
Yeah, so there is proposed language. It has not even hit committee, but the best way to catch up with that, and there is to go to the National Academy of Elder Law Attorneys page, NALA. I know we're not here to talk about elder law issues, but it does cover special needs. So yeah, there is some proposed language to eliminate the payback provision and also Medicaid estate recovery. I don't see that happening, but maybe it will. Maybe that slow boat to China will get there.
Yeah, hopefully. Well, I know we're out of time for today, and we've talked about a lot of things. And on our YouTube channel, we definitely have presentations on all of these topics, like a whole presentation on a letter of intent, a whole presentation on ABLE accounts, guardianship, SSI and Medicaid. Oh my gosh, there's lots of information out there because that is a challenging topic in itself. But just know that when you get today's slides, when you get the email with today's slides and the recording, you're going to have our contact information as well as Christina's information, how to get with us should you want to schedule an appointment. And there will be a link to the YouTube channel as well. And I'm happy to include our template of the letter of intent. I'm happy to include that. There's no monopoly on good ideas, and if that helps you kind of get your stuff, in order, and it helps you plan, it's better to have a form fillable document than hand scratching this out on a notepad. So we'll attach that to today's email as well. I know that I don't think we haven't really got through the rest of these slides. Did you want to comment on this?
So just a quick comment. So here's the thing: there are different ways to take money out of the supplemental needs trust for your child to maximize the SSI. So I'll just kind of leave it at that. I'm sorry, it's a little bit more detailed than what we have time for. Can you go to the next?
This is actually, I want to say this. This is a good one because the big deal with SSI and Medicaid, we're nationally certified as Social Security advisors, is there is a 1/3 reduction. If your child basically isn't paying rent or their fair share, there's a 1/3 reduction to their SSI. So if your child is getting SSI and they're not getting $841 a month, there's a good probability that they're having that 1/3 reduction going on. And so there's ways to fix that. Christina can help you with that. We can help you with that. But just know, and then there's a myth out there, and she hit on this earlier, that you cannot pay for food and shelter out of a special needs trust. And the truth is yes, you can. Yeah. You can, but there would be a 1/3 reduction, but a lot of people don't care about that. And it also depends, sometimes we've seen people in residential facilities, and it depends on how the residential facility bills on
Yeah.
whether it's actually considered food and shelter.
And
So
remember,
anyway, there's all kinds.
Yeah, and you can also use the ABLE account to offset some of the 1/3 reduction, because anything that comes out of the ABLE account is not income to the beneficiary, and so you can pay for food.
So you can, the bottom
Mhm.
line is you
Mhm.
can pay rent out
Mhm.
of the ABLE account
Mhm.
without that reduction. So anyway, just know that if you're getting less than 841, we should probably chat, because you're probably not maximizing the most that you can get. I think we're basically out of time. We just had one more slide. Here's her contact information. Again, it's going to be on the email. We've got our contact information. If you're interested in scheduling a free consultation, you can follow that link and the QR code or the email. And as always, Christina, we go deep and wide on these subjects, and I'm sorry that we're out of time, but you're wonderful. And like
I feel the
a
same
true
way about you,
professional.
Allison.
You're just doing a great job and making a big difference in our community, and I'm happy for that. The truth is the journey is tough. It's hard. It's a lot of information, and it is hard. But you guys are in the right place. We can definitely help you. And thank you, everybody, for spending your lunch hour with us
Y'all,
today.
thank you so
again,
much.
Christina.
Thank you. Thanks, everybody.
Take care. Bye now.
Y'all too. Bye-bye.